good morning or afternoon or evening or whatever time it is that you're watching this. Let's talk about the administrative law concept known as Skidmore Deference. Now that Chevron's overturned, it's definitely worth discussing Skidmore. So Skidmore Deference was given birth to in the 1944 case of Skidmore versus Swift & Co. It was decided unanimously. The opinion was written by Justice Robert Jackson. And what's sort of ironic or funny about Skidmore is that it was decided 40 years before Chevron was, and now Chevron just got overturned in 2024. So it looks like Skidmore has outlived Chevron, even though Chevron tended to be more important. Skidmore wasn't really important until arguably the 90s or 2000. So what happened in the original case in 1944? So in Skidmore versus Swift & Co., you had 7 employees who worked for Swift & Co., the respondent, and they were suing under the Fair Labor Standards Act because they wanted to get some overtime pay for these hours that they spent basically off clock, but on the premises at their workplace, not doing anything, but waiting, basically being on call. And they lost in the district court. Their claims were not viewed favorably. The courts didn't think that it could be considered working time. Now, they relied on an opinion by the Fair Labor Standards Administrator, which said that waiting time can be considered work time. And it's a flexible test. It kind of depends on how idle the workers are when they're waiting, or if they're sleeping or eating, then that's not really work. But the administrator put forward the opinion that it could be work. And so what the Supreme Court ended up holding was that nothing in the statutes, the FLSA statutes, precludes waiting time from being considered work time. So they gave what's called Skidmore Deference or Skidmore Respect to the opinion of the administrator. Basically, they recognized that it constituted a body of expertise, some specialized experience, and it was worth giving some sort of thoughtful consideration to. Not necessarily deference to, but we're going to consider it. And so that kind of set the standard that would start to get brought up more in the 2000 case of Christensen versus Harris County. This was not a unanimous decision. It was decided in 2000, so 56 years after Skidmore, which basically went on to articulate that stuff that comes in opinion letters, guidance statements, enforcement guidelines, basically stuff that didn't go through notice and comment procedure, in 553 of the Administrative Procedure Act, all of this stuff that has sort of a legislative process to it within the agency. This opinion stuff, basically. This can be entitled to Skidmore Deference or Skidmore Respect, but only to the extent that it's persuasive, that it has the power to persuade. So if it's kind of just a mindless, unthoughtful opinion from the administrative agency, it's far less likely to get Skidmore Deference. On the other hand, if it's really well reasoned, if it relies on good evidence, if it represents sound, thoughtful judgment, then it's more likely to get Skidmore Deference. And then we saw the year after that in 2001 in the case of Meade, where basically the court held that a tariff classification would get Skidmore Deference, but not Chevron Deference. And you had, within the context of the Supreme Court, a good number of different views on Skidmore Deference. You had Justice Scalia really criticizing it, saying it's an outdated concept. I mean, it's literally from the 1940s, saying that he actually likes Chevron because Chevron is much more simplistic, and we don't need to add in this layer of Skidmore Deference because it kind of undermines Chevron. You had Justice Breyer's opinion. It was actually a dissenting opinion in the case of Christensen that I thought really well articulated the principle of Skidmore, where he basically said that where the opinion and the views of an agency represent specialized experience, then the courts may pay particular attention to it. And Justice Breyer is a judge with a lot of administrative law experience, and you can kind of tell that because his admin law opinions are usually well written, they're really thoughtful, and I just thought that was a really good way of summarizing Skidmore. So yeah, it's relevant in the context of Chevron. or at least previously in the context of Chevron, because Chevron's gone. Because with Chevron, you had step one with, is the regulation or the statute ambiguous? And then you kind of moved on to a sort of step 1.5, where you looked at whether or not Congress actually delegated power to the agency to use the force of law, basically in rulemaking, and putting it through notice and comment procedure. And if it didn't, then it can't get Chevron deference. That was basically what Mead articulated. So instead of Chevron deference, if it fails at that so-called step 1.5, it goes into the Skidmore analysis zone. So they look at, okay, is the evidence the agency relied on thoughtful? Does it use valid reasoning? And then another important thing is, has the agency been consistent in their propositions? So for purposes of Skidmore deferences, it's basically a huge red flag if the agency is just flip-flopping all the time. That indicates a lack of thoroughness, a lack of thoughtfulness, maybe some ulterior motives of just relying on whatever they think is convenient, that they're not really thinking things through well. So yeah, that's basically Skidmore deference. It's definitely something that's important in the admin law context. We'll see how important it continues to be now that Chevron's been overturned. But yeah, law students who are in admin law, I know can get kind of confused about Skidmore deference. Chevron's no longer the law of the land, but back when Chevron existed, people were kind of confused about when does Chevron apply or when does Skidmore apply. But now that Chevron's overturned, I get the sense that it'll be easier to tell when Skidmore applies, because you'll basically just need to look at if the agency's just not acting under the force of law. They're not doing something, they're not promulgating a rule or any sort of interpretation that has the force of law on regulated parties. They're just issuing a guidance statement, an opinion letter, enforcement guidelines, just something generally that's not exactly a rule or a regulation that's gonna affect parties outside of the agency. So yeah, that's Skidmore deference. I know it can definitely be confusing to some people, but I really hope that this video helps you understand Skidmore deference, helps you understand what it's about, sort of the factors that go into it. And I hope that admin law nerds like myself will enjoy seeing what happens going forward with both Skidmore and the overturned Chevron.